Hi, I'm Peyton from LawCloud. I'm happy to be here today with securities attorney Usman Shaikh of US Law Group in Beverly Hills, California. Usman is here to answer frequently asked questions about the Form C process. The Form C is a detailed disclosure document that is required to be filed with the SEC by any company raising money through equity crowdfunding. Thank you for joining me, Usman. I would love for you to start by sharing a brief overview of your background and specifically your experience working with small companies preparing to launch a crowdfunding campaign.
Nice to be here, Peyton. I started my career over 15 years ago as a corporate attorney on Wall Street, where I focused on the areas of securities and corporate finance. Eventually, I moved to the West Coast and founded my law firm, US Law Group. Our firm is now bicoastal with offices here in Beverly Hills and also in New York City. Our mission is to bring the sophistication of big law with the attention of a boutique law firm. And right as our law firm was establishing itself as a premier boutique firm for corporate transactions, regulation crowdfunding came into effect, specifically in 2016. This gave smaller businesses and startups unprecedented capital access to the capital markets. Prior to Reg CF, crowdfunding was limited to rewards-based investments generally, like on Kickstarter, where people would get rewards such as early access to a product for contributing capital to a startup. Well, Reg CF changed all of that. And with my background as a securities lawyer who worked on big IPOs on Wall Street, it was a natural fit for me to help navigate smaller startups through this new and exciting area of securities law. And as Reg CF has evolved, I've kept up to speed and have been able to advise my clients on various changes in the law.
A lot of companies aren't sure what type of security to issue. Can you talk about the different types of securities and which ones are most common?
I think when the general public thinks of startups raising capital, they envision Shark Tank, whereby a founder is giving up X percentage of his or her company for a certain dollar amount. That is traditional equity financing, whereby a company, we call them the issuer, is selling shares of its common stock at an agreed upon share price. And that is generally what we see in equity crowdfunding offerings. We rarely see, for example, preferred stock being issued in crowdfunding because, generally speaking, preferred stock offerings are done in later funding rounds with venture capital investors. But over the years, issuers have started offering other forms of securities under Reg CF. We now see, for example, convertible notes being offered, which are essentially debt instruments that convert into equity upon the occurrence of certain events, such as a future financing round or a merger or an acquisition. If one of these events doesn't happen within a certain period of time, the investor is entitled to repayment of the investment plus interest or conversion into equity. Some Reg CF platforms have gotten creative and started offering securities known as crowd safes, which stands for Simple Agreement for Future Equity. These function similar to convertible notes in that they convert into equity in the future, but they are not debt instruments and they do not have a maturity date. For the most part, that's very favorable for the issuer. They convert at the discretion of the issuer, and since they're not debt instruments, the investor does not have a right to repayment if a triggering event fails to occur within a certain period of time.
What are the reasons why issuers would choose a convertible note over a safe? And what is the difference between the two?
Whether in crowdfunding or in private placements, the main reason an issuer will choose a convertible note or a SAFE is to avoid the need to determine a valuation for their company. Coming up with the right valuation, especially for an early stage company, is quite tricky, and it can have long-term consequences for both the company and the investor. For example, you can lose an investor if they think you overvalue the company. Now, going back to the Shark Tank example, we've all seen founders haggle over the valuation of their company with the sharks and how much of it to give up. Well, convertible notes and safes avoid this issue because they're not equity securities. Now, while both convertible notes and safes convert into equity upon triggering events, as I pointed out earlier, the main difference between the two is that notes are debt, meaning that they have a maturity date and upon its expiration, the investor gets repaid or converted. And notes are also reflected on the balance sheet of a company as debt. A safe, on the other hand, is not a debt instrument. So it doesn't have a maturity date. It doesn't show up as debt on the company's balance sheet. It's literally, as the name suggests, a simple agreement for future equity. If the triggering event doesn't occur, the investor has no recourse. While safes are common in venture capital, where the investors are in the business of investing and highly sophisticated, there is some controversy around safes in the crowdfunding space. In fact, in 2017, the SEC issued an investor bulletin cautioning investors against crowd safes. This came about because of the public's lack of knowledge as to how safes work and the SEC's stated mission to protect investors. The bulletin was designed to educate the public, specifically pointing out that safes are not equity securities, that there's a chance that they will never convert into equity, and that investors have no rights to get repaid their investments.
What about issuing a straight debt versus a convertible debt?
There are a handful of Reg CF portals that offer debt crowdfunding. In these scenarios, the investors lend money to the issuer and get repaid according to a set payment schedule or from the issuer's profits or revenues. These are more common in real estate deals or restaurants than, say, tech startups.
It's so helpful to have spent this time with you, getting some insight on these seemingly complex topics. Before we end, can you share your thoughts on working with a legal technology partner such as LawCloud to help improve the overall Form C experience and to bring down legal costs for small companies?
I gotta say, I love LawCloud. LawCloud came out in 2016, right when Reg CF was implemented, and it's been at the forefront of Reg CF ever since. And I've been working with LawCloud since the beginning. LawCloud provides a tool that streamlines the Form C process. For those who may not know, a Form C is an offering memorandum similar to a PPM for private placement offerings, which gets filed with the SEC before a Reg CF campaign can go live. The Form C has many disclosure requirements, including business and securities risk factors that a layperson generally wouldn't know how to properly address. Hiring a law firm to create a Form C from scratch can be quite expensive. And of course, you'd have to find a lawyer who specializes not only in securities, but is up to speed on Reg CF. So LawCloud has an easy-to-use interface, which allows an issuer to input information, which is then generated into a Form C, which is fully compliant with SEC regulations. The Form C then goes to a lawyer like me for review, and then it gets filed directly with the SEC through the LawCloud portal. It's very time and cost effective.
Thank you so much for your time today, Usman. I know that some issuers will have more specific questions about the structure of their raise and wanted to let everyone know that you'll be offering starter consultations as well as the Form C attorney review through LawCloud. Please follow the instructions on the next screen to get in touch. Thank you everyone for being here, and we'll see you again soon.